This is another in our series of videos on how the Medicaid rules apply in the case of a married couple. Let's talk today about what assets the community spouse, the one who is not in the nursing home, is entitled to keep. First, in addition to the exempt assets that apply, otherwise different videos on that, one important thing here is that the community spouse is entitled to keep the residence. But in addition, the community spouse gets something called the community spouse resource allowance, an amount of non-exempt assets, which generally means financial assets that spouse gets to keep. In Illinois, it is a fixed figure, $109,560. In Missouri, it's not less than a minimum, not more than a maximum. For 2018, the minimum is $24,720 and the maximum is $123,600. So the community spouse gets to keep half of the assets subject to that minimum or maximum. That fact that the community spouse gets to keep assets has a lot to do with the planning that we do to help community spouses, figuring out what things that we can do to have them keep as much as possible, maybe using some of the money and converting it into exempt assets that they can keep, figuring out which assets are the wisest ones to keep, which ones are the wisest to convert to income or do something else with. Really a complex subject, but the good news is one that in the right hands can produce some really, really positive results for you. It's something for which you really need an elder law attorney. We're very experienced in doing this, getting very good results for people, and we'll be happy to help. Thanks.